Welcome. This is Robert Schein, Managing Director and Partner with Blanke Schein Wealth Management. And today I'm really excited to have a special guest with us, Valerie Powers Smith. She's an estate planning attorney, both in Palm Springs and in Indian Wells office. So just down the street from our office here in Palm Desert. Valerie, how are you doing today? Welcome.
Thank you, Rob. I'm doing great. How are you?
Good, thank you. We're all adjusting to the new normal. I think we're just doing our part to make certain that everyone's staying, healthy and safe as we get through this together. Valerie, let me ask you a question. You're a partner, you're a local estate planning attorney. Tell me about yourself a little bit and go into your background for me.
For a little bit of background, I'm born and raised back east, the suburbs of Philadelphia. I've been living in California now since 2006. I maintain practices in New Jersey, Pennsylvania, New York, and California. And I've worked on all things estate, trusts, and probate with special needs and elder clients. I am a partner at Slovak, Barron, Empey, Murphy, and Pinkney. And as you had already mentioned, locally we have offices in Palm Springs and Indian Wells, but we also have offices up in Orange County and San Diego, as well as Manhattan and New Jersey.
Wonderful. In this new world that we're in, a lot of us, including myself, have to look at my estate plan, where I am, even dusting it off and updating it. I think there's a lot of things. One of the reasons why I wanted to have this conversation with you today is for that you can communicate to my audience, my clients, friends and family very specifically, the things that we should be on top of, thinking about. Let's start with the basics of just the basic financial or estate planning, if you will.
The basics would be, it depends on what jurisdiction you're in. It depends on what the size of your estate is. And I think that word sometimes can be off-putting, that people think the word estate means they have great wealth. Estate is just a generic term that says what you own, from your house to the contents to your personal tangible belongings and things that are in a bank or a financial institution. So at a minimum, the basics are a will, which is also known as a last will and testament. And so in some states, a will is sufficient to be able to appoint who's going to be in charge of your estate and to dictate how you want your belongings to be disposed of upon your death. In other states, such as California, you often are going to want to have a revocable living trust as a combination with the will, which we then call a pour-over will, because it's meant to push any assets that aren't in the trust at the time of your death into that. And the whole point of doing that is to avoid the California probate process. It also gives you privacy of the process because the trust administration isn't subject to court supervision. You don't have to file those documents. And it also is less expensive because you're not paying court fees and things of that nature. And you can go at your own pace, although there are general guidelines versus what the courts dictated year-long processes for the probate of an estate.
So basically, it's the framework of instruction, legally speaking, because we hear oftentimes there's two things you address. Number one was, I don't know if I have enough, my assets total, to have, quote unquote, an estate plan, right? From a net worth standpoint. It's really, that's not it. Especially living in California, you want to have everything you're just talking about, from that to advanced medical directives and legal, medical power of attorneys. And because you also want to, the trust in pour-over will, because you want to avoid probate, right? I mean, that can be truly expensive. So there's a penalty for not having everything looked after properly.
Yeah, I mean, I think the penalty is a good word to use, because I think people have to get over a couple of hurdles. And I say this with all due respect, but one hurdle is embracing that there is an end to the natural course of life, and you do have to plan for that. And I understand that's an uncomfortable conversation for people to have. The second is that people don't really want to spend the money. And so they just, I won't be here and someone else can figure it out, won't be my problem. The issue is, I would say, I'm probably being generous, but at least 50% of individuals are very clear on who they want to inherit what they own. And if you don't do any planning by way of a will or a will or a pour-over will with a trust, then the laws of intestacy, each state has their own statutory defined inheritance laws, and it's called intestacy. And so they look at what is your bloodline and who will inherit. So for example, If you pass away without a spouse surviving you and without children, and you have parents, say if you're estranged from your parents are the ones that are first in line to take. Or say if it's you're estranged from a sibling, or you may not have had siblings and it's going all the way down into the cousin line. You may have people you don't even know or don't like, and you may have wanted to make charitable bequests, for example, or have helped someone else in your family or a friend, or any number of choices. And the laws of intestacy will negate those choices, and it will also dictate who has priority to be in charge. And that person who has priority may be someone you don't trust and would not want to be in charge of your assets. So there is a penalty. For
so
sure.
right there, especially if you're like you or me or anybody out there, most, if not all of my clients, we've worked really hard for what we have. We want to be in control versus having that just thrown to the wind in the court system, if you will, if we don't take the proper necessary steps to plan and plan properly. So proactively, that proactive is the key word here, just to get out of it.
Yeah, absolutely. And I like people to understand that while these are documents that become effective upon execution, you should really look at them as a living, fluid document that you should be revisiting in the same way that you revisit your financial plan as your goals and your life changes. People can have falling outs, people can take ill, someone could predecease someone, or you may start having an estate that you need to be looking at charitable or tax saving planning, or you want to do legacy planning or give back to a particular institution where you received your degree. So people do need to know that it's just trying to set the foundation that you finally have made a decision and executed these documents, but it's not forever. You can make amendments to the trust. An amendment to a will is called a codicil. The point is you can make changes to your fiduciary appointments and you can make changes to your bequests. And I think sometimes people are fearful in proceeding with the process because they think that's it. It's forever what they've decided. And so I think people do need to understand that they have that flexibility as long as they have capacity and are alive.
Valerie, that is so huge that you brought that point up. Because I mean, at the end of the day, there's two things that are constant: life changes, and our laws change from estate planning. We just saw that change most recently within the last few years. So what we need to do is create the foundation, the framework, if you will, but also have the pliability, the flexibility that as your life changes, to go in and connect with your estate planning attorney to make certain that it's in line with your current situation in life, your goals and your feelings. Oftentimes, my wife and I, before we had kids, were like, we have to set this up. And then you have kids, a couple of kids are named in the trust and a couple of them aren't, but they're all covered, like you constantly go back every 2 to 3 years. What would you recommend? Because life changes so quickly that you always put this stuff on the back burner. It's one of the reasons why we're having this conversation today, is because, we all have time at home. We all want to rethink some things. We also want to be proactive and get that done. But how often should I look at my estate plan, if you will, and have it reviewed?
Well, I say to my clients at the time of execution, put these with your important documents. Think about on an annual basis, you're having to pull out documents to look at tax preparation. Might want to think at looking at your financial plan at that time. Might want to look at where's your estate plan fall in, because a lot of times you may think, well, why would that be relevant? Well, taxes, you're looking at your assets and you're looking at documents. When you're dealing your financial planning, you're doing the same thing. If you have a trust as part of your estate plan, I always have a schedule on the ends that makes a formal declaration of these are the assets that I intend to be funded in this trust, because just because you do the trust doesn't mean that upon your death, all those assets would be in there. We're not going to also have a probate problem. And so I try to make sure those assets are there. So if they're looking at the asset driven focus, then maybe they see, hey, we don't have that house anymore. We have 2 more commercial properties that we never put in the trust, and that could cause a probate problem. That then makes them look at, hey, maybe we should look. Didn't we name Alan? And Alan now has dementia. We better make sure that we change our successor trustee designation. Or it could be, our daughter has just been diagnosed with a significant condition that we think that she's now going to have to go on some sort of means tested assistance. So now we need to amend that bequest to her by instead giving it to a special needs trust so we don't disrupt any of her benefits. And so I said in the beginning, I optimistically look at it annually. I think that reasonably means that people are probably going to look at it 3 to 5 years. But I always say to people, life circumstances or what should be your trigger. So marriage, divorce, death, incapacity, or a child coming in, and it's not necessarily your immediate family, but your overall family. So if you're married and your children then get married or have children, that should be a trigger that you should look at. Have I addressed everybody the way that I want? I do try to talk to people before executing to see, let's just do the best we can with the now, but talk to me about what's on the horizon. And that may be something similar you do with your clients about, okay, well, I see what you have now. What are your goals? What may change? What things do I need to be prepared for? Such as, we're not done adding to our family. We may have another child. Or for the pet lovers out there, like we might be getting another pet. I do include pet trusts within what I do because I know my dog is my child. And so I want to make sure he's properly cared for. So I like to say, if people do think that there might be an addition, that you include after born or after acquired, because you might adopt a child or an animal, that they want the same treatment as they've stated here. And so if you, at the time you sat down with me, for example, only had 2, but you knew you and your wife weren't done or wanted to leave the door open, and you end up at the time of your death having 4 children, then each of them would have an equal share because of having that language in there. So that's how I plan, and that's how I like people to look at it, knowing that, I myself have to do an amendment and I haven't done it yet.
Yeah, that is so relieving to me, because I'm really, grateful for this conversation, because we're sort of going through all of the concerns that my clients have on a daily basis when I have, the annual portfolio review, but also the financial planning review. And we look at, we have the conversation about taxes, but also estate planning, and everything you just discussed. I think it's going to be super valuable to our clients. So I really appreciate this time together today.
Well, and I think, Rob, for you, it's also important, and I don't want to discount, you did mention in the very beginning, but I think a lot of times when you talk about estate planning, capacity planning gets left behind. And I think that for some people, they may have already sorted out their estate plan, maybe exactly the way that they want, and they're happy with their fiduciary appointments, but they don't have a power of attorney for financial or medical decision making. And sometimes people just are like, well, I don't want anyone in my business while I'm alive, but then something may happen. Often it's, I've had to step up for my parent, or my neighbor's parents have this situation and they're now in the caregiving role. And so I can't emphasize enough how important it is to make sure that that's taken care of, particularly for professionals such as you, that you want your clients to know that you can continue to do your job, and that the person who they've authorized to direct you, that you've already discussed that with them and they've shown that they have an instrument. And so that can be a temporary issue that someone has to step into the shoes of someone else, or it could be permanent because someone has been declared incapacitated by a court, or physicians have indicated that that person no longer can manage him or herself or manage their financial decision making. And that could be your personal business, your investments, entering into contracts, or even engaging in any sort of estate planning. And so those are really important, and people should know, be very careful. That person becomes you. That person is to effectuate your decision making, not what they want for you, but they're really trying to give you a voice when your voice is muted because of incapacity, again, either temporary or permanent. So those are really important instruments that people need to consider and look at their own estate plan to see, is that part of what I have? If not, I should take care of that.
That's great. Valerie, I had a question for you, because you're now sparking a lot more questions for me, even beyond this conversation today. If you're at home, I'm at home, and work, everything else in this new world, we don't know when we're going to get out of this. We all pray that sooner than later, sooner than later, and we're definitely thankful for all the medical professionals and science, whizzes that are out there that are going to help us get through this, hopefully sooner than later. But is it something where I could call you, after this phone call and have a consultation, if you will? It's no different than you being at your office, right?
That's right. I would say we have all had to adapt at warp speed to Zoom or whatever other platform. People are embracing the telephone the way we embraced it when we were children, a lot more people on the phone. And so really, I was inundated for about 20 days, I'd say, with people calling me or doing web conferencing, wanting to either finish their estate plan that they had started with me, or new clients that thought, yeah, this seems like the time that I should be taking. And plus, people have more time on their hands that they're able to be thoughtful about the consideration and be available, be with their partner or spouse if it's a couple, and really make those decisions instead of trying to fit it in over the weekend or work schedules. And so, yeah, we can accomplish everything by telephone, video conference, or even email. It's just what someone's preference is. And then when it comes to execution, although I received an email this morning, multiple states have had governor's orders or legislative changes to the notary. California still hasn't made any changes for remote notarization by web conference, which would be as if, you know, I'm the notary watching you right now on the video. And so what we have done is largely because banks are essential businesses still under the governor's order, I first say to my clients, check in with your bank. It's a service that banks offer to their clients to notarize documents, not just necessarily estate planning, but, you know, anytime someone has something.
That's a good
and
point.
so I would say a vast majority of my clients, once we've been done and they give me the red or the green flag, not the red flag, I have my paralegal send out all the documents with very clear instructions on how to execute, with tabs where to sign, initial, or notarize. They go to their bank, have them taken care of, and then they send them back. Obviously, the bank has protocols of the social distancing and masks and gloves. And when that hasn't been able to be taken care of by their bank, some people have engaged a mobile notary on their own. I've heard of people setting up desks in front lawns. You step up and sign with your own pen, mask, and glove. You step away, let the notary step up, again, mask, glove, with her own pen to be able to record the instruments that are being done in their licenses. And then really the third is a social distancing drive-through in the back of my firm. And we've done that where people, you know, are really panicked, want to take care of it, and none of these other options have worked for them. And we send them a long protocol, and it's literally like the testing zones. You're coming in your vehicle, gloved, masked. We hand a sealed envelope through enough of the crack of the window. We watch them execute. They hold their license up so my notary can take a picture and record that in her book. They pass it back. My notary and witness go back upstairs, and then they finish the processing. And it's like a 5 to 10 minute process, but that everybody is protected, the 6 feet, you know, and all the rest of it. So we will get it done. I am committed.
Yeah, that's great.
That anybody who needs their estate plan done, it's really, if we can alleviate concerns in the community about that issue during everything else that we're dealing with, you know, I'm happy to take care of it. So there are ways we can take care of
Well,
it.
Valerie, again, there are businesses that I know that are adapting to this new daily life that we're living in and thriving. You know, in your, you know, that consummate professional that is just, you know, taking it to the next level. So that's why I was so excited to connect with you today, share some insights. I'm sure there's a lot more that we could discuss, but I just want to keep this as, you know, informative as possible at this moment in time. And I just thank you for your time today.
Thank you. Pleasure.
And I'm looking forward to another one of these. Maybe we'll do it, you know, 6 months or even another 3 months.
Sure.
And we won't have the same sort of conversation about gloves and masks. I think it'll be a different world for the better.
Yeah. Take care and stay safe.
Thank you. You too, Valerie.
All right.